Thanks to American independent journalist Michael Richardson's hard work, on June 21st, 2022, the UK's Information Review Tribunal made an important decision regarding the publication of Tsai Ing-wen's examiners' identities. Perhaps this decision has our viewers confused. Why is it that investigators lose one moment and then win the next? How many tribunal cases is Michael Richardson tied up in? Let us straighten things out for everyone. The first-tier tribunal on September 3, 2021 handed Richardson a loss. That particular case was in regards to a ruling the ICO made on June 11, 2020. This ruling was filled with contradictions. In it, the ICO agreed with the University of London that the school did not need to publish Tsai's viva date or examiners' names, so Richardson took the ICO to tribunal over that ruling. Ultimately, the tribunal ruled in the ICO's favor, citing closed documents that were said to contain Tsai's viva date and examiners' names. That particular case is awaiting an appeal hearing in the UK's High Court. The case that most recently ended in victory was in relation to an ICO ruling published on November 26, 2021. In that ruling, LSE said that it did not have records on Tsai Ing-wen's examiners or viva, so the ICO said LSE could not provide what it did not have. Michael Richardson also took that ruling to tribunal, which came back in our favor on June 21st. One case is in relation to an ICO ruling made on June 11, 2020. The other is in response to a ruling made on November 26, 2021. The text of the pivotal tribunal ruling says, the tribunal finds that decision notice IC 109451-SIM2 dated 26 November 2021 was erroneous and that materials within the scope of the information request is held by LSE. Another point in the ruling stipulates, LSE must within 28 days issue a fresh response to the appellant's original information request, which confirms that information within the scope of his request is held, and either disclose it or claim any exemptions to disclosure on which it relies. This ruling could have far-reaching implications. In fact, it could be the very thing to bring this academic dishonesty to justice. The court's ruling has overturned much of what the University of London and LSE has claimed over the years. By doing so, the courts have pretty much proven that all of the school's shenanigans that we have covered are true. From using archived records as false evidence in court to getting an unworthy thesis placed in libraries, all of it was just a ruse to rewrite history. This false information was, furthermore, used to dissuade truth seekers in Taiwan. This international scandal has evolved from an instance of academic fraud to a conspiracy that deprives hard-working scholars of their human rights. The devils are in the details. Today, we will dedicate this episode to deciphering the tribunal ruling and the truth behind it. First, the tribunal ruling has confirmed something very important. That is, where Tsai Ing-wen's viva records are being kept. They're being kept at LSE. That's the only possibility here. The University of London said as much in 2022 on a whatdotheyknow.com thread. But the ICO said that LSE denied holding Tsai Ing-wen's viva records in its November 26, 2021 ruling. Therefore, it must have deduced that the records were at the University of London. Michael Richardson then pointed out that LSE legal team head Kevin Haynes had provided Taiwan's courts with evidence attesting to the identities of Tsai's examiners. That simple act alone rendered LSE's testimony in the ICO ruling false. It's clear that the tribunal took issue with LSE's contradictory behavior. Back in November 2021, the ICO said this in its ruling. The LSE was satisfied that no relevant information had been destroyed, and that the reason that it did not hold the information now was that it had never held the information because the information was held by the University of London. The ICO had no problem agreeing with what LSE said. The ruling declared it is logical to consider that it would be the university that has the records pertaining to President Tsai's examination, and the commissioner has already established that these records are, as a matter of fact, held by the University of London. However, when the ICO established that the records were held by the University of London, they came to that conclusion after referring to the June 11, 2020 ICO ruling. That ruling is the same one that Tsai's lawyer used as evidence in Taiwan. In the ruling, University of London Information Compliance and Records Manager Kit Good gave false testimony to the ICO, saying that the University of London had records of Tsai's viva and files about her thesis's publication. LSE and the ICO were engaged in a cycle of mutual confirmation. Each endorsed the other to escape scrutiny. 3 years later, though, these two institutions are still avoiding Richardson's request, which is, no matter who has it, please publish Tsai Ing-wen's viva and examiner information. Tribunal Judge Alison McKenna rejected the ICO's ruling, finding it to be erroneous. She believes that the information, Tsai's viva records, and examiner names are being kept at LSE. This one ruling has unraveled the ICO's lies. In 28 days, LSE must hand over records indicating who Tsai's examiners were and when her viva was. In 28 days, Tsai's academic dishonesty will have to see the light of day. As we all know, LSE never had Tsai's viva records because Tsai never had a viva. LSE tried pushing the responsibility onto the University of London, but Alison McKenna brought LSE back to harsh reality. Just so we're clear, if the records exist, they would have been published by now. Though the tribunal ruling addresses the ICO, the ultimate takeaway is that LSE infringed on the UK Freedom of Information Act. The tribunal has given LSE 28 days to come clean and redeem itself. If in 28 days LSE cannot come up with a reasonable explanation for why it should be exempt from transgressing the FOIA, then anyone can take the tribunal ruling and take LSE to court for what it did. Let's talk about LSE exempting itself. The ICO also once said that the University of London did not need to publish Tsai's examiners' identities because that information was Tsai's personal information. That was proven to be untrue after we uncovered who Su Wei-chun's examiners were after a simple Freedom of Information Act request. If LSE tries to use the same defense, they will only contradict themselves. We don't know if Alison McKenna is out of the loop or not. However, this ruling, in theory, should ultimately remove Tsai from controversy. It would be a good thing for Tsai Ing-wen. However, the ruling also completely undoes the ICO, the University of London, and LSE's efforts to obscure this entire matter over the past 3 years. No judge in their right mind would ever consider that a member of a school's legal team would fabricate evidence and submit it to another country's court. So, if LSE shows the same information that Kevin Haynes gave to Taiwan's courts, then it's likely LSE can walk away from this ruling unscathed. No judge in their right mind would believe that the ICO would orchestrate a cover-up for another country's head of state, going so far as to falsify records and fool the tribunal, but this has all happened for Tsai Ing-wen. The devils are in the details. Let's consider another part of the ruling. The tribunal considered an agreed open bundle of evidence comprising pages 1 to 86. It also considered submissions from the Public Authority, the Council of the London School of Economics and Political Science, and further evidence and submissions from the appellant. Remember the tribunal decision that handed Michael Richardson a loss on September 3rd, 2021? Remember how that decision hinged upon what the courts called a bundle of closed documents? Why was this bundle of documents not mentioned in this most recent hearing? If that evidence helped the ICO win in court in 2021, why was it not brought forward in 2022? It's because in the 2021 case, the University of London claimed it had Tsai Ing-wen's viva and thesis information, but it could not share it with Richardson because Richardson lacked legitimate interest. In this case, the ICO could use closed documents to bamboozle the court. It didn't matter who the examiners were, the University of London just had to prove they had some kind of record. However, the case at hand now addresses LSE's claims that it does not have Tsai's PhD records. LSE needs to prove that it denied holding the requested information. It cannot indicate any inkling that it had any information at all. The two cases are inherently different in nature. Therefore, the evidence they need is different as well. If LSE provided the closed documents, then it probably gave the tribunal the 278-page document Kevin Haynes provided. This would undo the ICO's report, which claimed the University of London was the one to hold Tsai's records. That would also make the ICO look very bad. It's clear the ICO holds all the pieces in its hand. It has a very clear idea of who has what. However, it refuses to provide this complete picture to the court. Instead, it distorts the truth to fool the UK courts. This is how we know that the ICO is an accomplice to the scandal. It is not a victim. Richardson also gave the tribunal a copy of the evidence Kevin Haynes provided to Taiwan's courts, given to Richardson by Dr. Dennis Pang. That was to give the judge a more comprehensive idea of what was going on, so that she could come to the pivotal ruling that she ultimately issued. Alison McKenna said that LSE is the one that holds Tsai's information. She also said that the information must be made public within 28 days. She has backed the wrongdoers into a corner. The 5th to 8th point of the ruling is the background to appeal section. The following points are: 5. The appellant made a request to LSE on the 2nd of May 2021 for the names of the examiners who examined the then Ms. Tsai Ing-wen, now president of Taiwan, for her PhD and for the report from her viva. 6. LSE responded on the 4th of May and the 26th of May 2021 that it did not hold the requested information because at the relevant time, 1984, it was the University of London which awarded degrees to LSE students. 7. The Information Commissioner issued Decision Notice IC 109451 SIM2 on the 26th of November 2021. It concluded on the balance of probabilities that the requested information was not held by LSE. 8. The appellant appealed to the tribunal. LSE was sent the appeal papers and invited to make submissions or to apply to be joined as a party to the appeal. It chose only to make submissions but also supplied evidence. In reality, the first time Michael Richardson made an FOIA request for Tsai's information was on October 21st, 2019. Back then, Richardson only got a response from LSE Records manager Rachel McGuire. McGuire simply said Tsai's Viva took place on Sunday, October 16, 1983. McGuire then said that the University of London kept information on Tsai's examiners. Why was it necessary to launch a second Freedom of Information Act request for the same information? Because back then, the Freedom of Information Act request was done at the behest of Judge Zhou Yuxuan, who ultimately received Kevin Haynes' documents. Dr. Peng provided Richardson with the information beforehand, proving that the 2021 Freedom of Information Act inquiry was a calculated scam by the wrongdoers all along. LSE School Secretary Luis Nadal said publicly that the school did not have Tsai's relevant records. When that statement made it into the November 26, 2021 ICO ruling, that sealed LSE's fate and cornered the school. From all this, we can see that there are two internal factions at LSE. One faction is willing to work with Taiwanese authorities to cover up academic fraud. They not only came up with the Sunday Viva date, but they also provided two people who couldn't have been Tsai's examiners as her examiners. The other faction seems to want to at least partially adhere to the truth. This faction flat out said LSE did not have Tsai's records. How the ICO interpreted that information was up to the office itself. That faction just wanted to be done with the controversy. When LSE was invited to be part of the case, it declined. Instead, LSE confessed in the ruling, the information we hold on file is only there accidentally. We cannot be certain that this information is accurate. This was bad for the ICO. Where did the ICO get its trash information from? But really, how do you hold information accidentally? If LSE did practice proper record keeping, why would anything be there by accident? This admission implies that the records in question are not school sanctioned and instead provided by a third party. That's why they can't attest to the information's accuracy. The truth behind all these irregularities stem from an incident that happened in June 2020. At the time, the Justice Ministry dispatched Investigation Bureau agents to LSE to insert fabricated records into the school's archives. Since the beginning, all of this has been orchestrated by Taiwan's government. The ruling's 17th point further unraveled this scandal. 17. LSE confirmed to the tribunal that it holds President Tsai's student file comprising 278 pages. It stated that there is a letter on this file in which a person appears to self-identify as one of the Viva examiners, but that it has no official notification from University of London whether this information was correct, and it holds no information on the identity of the co-examiner. This point in the ruling alone is enough to solve this entire debacle. A prior University of London file dump shows that in 2015, the school did not have anything that could verify Tsai's degree status. If LSE should have Tsai's records but don't have them, and if at the same time the University of London doesn't have any records, then where can we find Tsai's PhD files? The reasonable deduction here is that all of the prior information the schools provided came from Tsai herself. The 17th point in the ruling mentions an email. The email is a correspondence between Kevin Haynes and Kristen Chen of Taiwan's Justice Ministry. In it, Haynes identified Tsai's examiners as the two people that couldn't possibly have presided over her Viva. The ruling stated, Commenting on the email of December 16, 2020, LSE states that its review found that the information provided by LSE in that email was likely inaccurate. This was based on a hurried view of a scanned file that cannot be keyword searched. The email chain is attached. LSE was completely backed into a corner, and to prevent further damage, it had to go in with a disclaimer that information it gave was likely inaccurate. This was based on a hurried view of a scanned file that cannot be keyword searched. The email chain is attached. But Kevin Haynes was not so discerning when he handed over that information to Taiwan's authorities for use in cases over there. By March 2021, it seems that most senior staff at LSE wanted to jump ship from Tsai's thesis controversy. It didn't matter though. The ruling has revealed thorough collusion between LSE and Taiwan's presidential office over the past 3 years. Point 19 of the ruling says, the appellant produced an email dated 14th of June 2019 from a member of staff at LSE to President Tsai's office in which there is a reference to fending off inquiries about President Tsai's PhD. The appellant relies on this as evidence that LSE is reluctant to comply with its duties under the Freedom of Information Act. The email mentioned here shows just how much an area of concern ThesisGate was for the presidential office. Not only that, but we see that LSE had been cooperating with the presidential office as early as 3 years ago. If Tsai's degree is real, why would there be a need to fend off inquiries? It turns out LSE has been an accomplice this entire time. This is why the presidential office had no problem deferring to LSE all throughout this investigation. They were in cahoots. Since LSE was part of Tsai's team, evidence was absolutely no problem. After Tsai engaged in legal action against Dr. Pang, it became obvious there was a need to identify 2 people as examiners. When the first 2 names didn't work out, another examiner by the name ZZ surfaced. However, ZZ would turn out to do more damage than good. Point 20 of the ruling says, the considered following evidence provided by LSE with its submissions of 14th of March 2022. An internal email dated 31st of March 2021 addressed to the member of staff who sent the 16th December 2020 email as follows. Looking at it again, I was wondering where in the student file you got the information that she had 2 internal examiners, XX and YY, and 1 external examiner, ZZ. The email's sender questions Kevin Haynes' account. At the same time, they seem to suggest a resolution. The sender mildly suggests that it's bad form for Michael Elliott, Tsai's supervisor, to be identified as one of her examiners, so she suggests a ZZ in his stead. The third suggested examiner is, of course, the person Ing-wen long referred to in court, Richard Dale. But since the presented information is, by LSE's own admission, likely inaccurate, how can this suggested third person be anything close to accurate? This email, if anything, exposes the methods by which the wrongdoers conjure false information. They use emails containing uncertain terms to fool the courts. The email correspondence goes on to say, as far as I can see, the only examiners referred to in the file are ZZ, named as external examiner in a letter from President Tsai to the Secretary of Graduate School at LSE from the 5th of December 1983. The wrongdoers, as we've correctly judged, started changing the story. They first falsely identified Richard Dale as a third examiner, then they began the process of removing Michael Elliott as an examiner entirely. All of this information came implicitly from Tsai Ing-wen. XX, who refers to my co-examiner and myself in a memo dated January 16, 1983. This also suggests there were only two examiners, XX and one other. ICYY is mentioned in the file, but couldn't find him specifically named as an examiner. Do you see what they did there? They removed YY as a potential examiner. It would be safe to wager that YY is Michael Elliott and XX is most likely Leonard Lee. No one replied to that last email. How could they, given the outrageous chain of events they described and implied? If we look closely at his replies to the December 16, 2020 email, Kevin Haynes only CC'd Taiwanese officials. So how would other LSE staff know about this email? LSE staff cited this email on March 31, 2021. When LSE says it has internal correspondence that can attest to what it says, these are the kinds of emails it refers to. 2 months later, in May 2021, LSE Council decided to jump ship. Perhaps they thought it was a matter of integrity. Perhaps they thought they were playing with fire. Either way, it's clear they wanted out of Tsai's shenanigans. As we mentioned earlier, this ruling has far-reaching implications. It's a very good indicator of what's to come for ThesisGate. First, the ruling invalidated any and all evidence that the schools have provided up to this point. It also showed that most evidence the schools had came from Tsai Ing-wen anyway. Second, the ruling also proves that the ICO went against the Freedom of Information Act to protect Tsai Ing-wen. Its prior rulings could all come under further scrutiny. Third, as we approach the High Court hearing date, LSE's plea may become the final straw that brings the University of London to its knees. After 3 years of hard work, we finally see our first major victory. This is when ThesisGate takes the offensive. This is where we mark the beginning of the end.